Greetings, everyone, and welcome to the conversation series on mediation, created with an aim and vision to promote mediation in the world around us and to talk about mediation from the perspective of a common person. We are here in season 2, and we are going to talk about mediators. We are going to unmask a mediator's life. And today, season 2, we have, I'll just introduce, and before that, I'll just take a short legal disclaimer that the views expressed herein are the personal perspectives of the speakers and may or may not represent the views of a larger professional community they belong to. And this series is being recorded for wide circulation. The conversation series aim to provide a general overview of the subject matter involved and may or may not represent the views of a larger professional community they belong to. So, this should not be construed as a legal or professional advice in any manner whatsoever. This session is being recorded for wide circulation. Let me introduce the guest speaker today. We have Mr. Nanchang Nangwang, DRS, Executive Director, Settlement House ADR Training Institute. Right, Mr. Nanchang. So, Mr. Nanchang is a lawyer and the principal partner of the firm Nanchang and Company, a law firm based in Kaduna, Nigeria. He is a certified teacher, trainer, and facilitator. He's a faculty member and the executive director of the Settlement House ADR Training Institute and uh, a training certification with the practice of ADR dispute resolution. He is also a member as well as a faculty member of the Nigerian Institute of Chartered Accountants, arbitrators. He is a certified conflict manager, a certified ADR registrar secretary, a holder of Mediator Academy United Kingdom certificate in commercial mediation accredited by the Institute of Chartered Arbitrators UK, a medical law enthusiastic and employment and labor law expert. So that's really interesting. He's an accredited and trained mediator with Accords International India and has completed a course to become a Florida Supreme Court certified county mediator in the United States of America. So he's a facilitator for the Professional Diploma in Education of Institute of Education, Ahmadu Bello University, Zaira, as well as an external facilitator with the Federal Polytechnic Kaduna. He's married and blessed with 2 lovely children. That's a short introduction of Mr. Nanchang. So, Mr. Nanchang, I was reading that, and medical legal expertise, and also you have with the Accords International India. So, first of all, let's ask you what prompted you to take up mediation, since you have employment and labor law expert and a medical law expert. So, what prompted mediation? How did ADR happen?
Well, back then in school, uh, I did not think that I will be a practicing lawyer.
Okay.
So it seems I do not really have a direction, so to say. So, but when I got to law school, and then we started, I don't know where I started developing interest for practice. So I got involved in class fund competition. Class fund is a body of lawyers or aspiring lawyers. It is called Christian Lawyers Association of Nigeria or Christian Law Student Association. So as at that time, it is Christian Student Association. That's Christian student. That's the body that belongs to the students. Okay. Class fund body. So I got involved in their competition, and then I served as a counsel, and it was really interesting. Even though I didn't get involved in this kind of practice back in the university days, we have firms that are classified in the university for the practice. So I was not too involved. So that was where I started. But then I got this advert in law school about ADR, and then one of the renowned professors that was championing the cause of ADR in Nigeria then, he was late, Kelvin Wosu. So he came, spoke about ADR, and then I got interested in it. So that's far back as 2013. So
Okay.
I decided to enroll for the training. The training was actually a three segmented parts. It was segmented into three. You have to do the first part, then you do the second part, and then you conclude with the third part. It was actually a training under the Dispute Resolution Associates. And it's actually a very comprehensive training that encompasses uh, conflict analysis. Can you hear me, Sona?
Yes, I can hear you. Conflict
Oh, that's good. So,
analysis. So what does that
yes,
mean? Yeah.
yes. Conflict analysis, negotiation, mediation, arbitration, and uh, um, management of cases, and then use of settlement options, in criminal cases. So these are the three parts of the training that you must conclude and before you become certified as a dispute resolution
Uh,
specialist as a then. And then I remember that back then I was in law school, and then the training as a then was actually very expensive because compared to now, when you look at 2013, we paid roughly about 60 something thousand, getting to 70,000 as at that time. And then I was a student, and then because of the value I feel I have in ADR, I decided to, cut down some of my activities and some of the things that I need to do in order to get enrolled for that training. And eventually, I concluded the three parts of the training that gives you a very foundational teaching in the basic aspects of ADR mechanism, which include the negotiation, mediation, arbitration, and then I will target restorative justice because we had a training on how to use, settlement cases in settlement options in criminal cases as at
yes.
then, far
That
back as then.
sorry,
So
I
that was
interrupt you.
how,
Sorry, I interrupt you
yes,
in
that was
between.
how I
But
started my journey.
there you have talked about twice about some training where facilitative or restorative mediation or ADR practice is being used in criminal cases. Can you enumerate a little about that more?
Okay, in criminal cases, you have just a minute.
Okay. Yeah.
In criminal cases, can you hear me?
Yes, I can hear you. I think your
Yes,
camera is
in criminal cases, we have compoundable and non-compoundable
non-combustible. Yes.
offenses. So it is not every matters that are actually amenable to settlements, but matters that are, that have their basis in maybe something that has to do with a person having much to say about the issue, like maybe possibly an injury, all this battery and some of those kind of things. You have the opportunity to be able to resolve those matters without necessarily taking the matter to court and then prosecuting it really as criminal matters. So but when it has to do with serious offenses like murder, rape, and some of those matters in that class, you do not have the opportunity to settle it because it is an offense that is considered against the state, and
Yes.
then the state is the one taking responsibility to ensure that they prosecute And then if you are convicted, you will be sentenced, especially for the fact that they want to deter other members of the community from, having something like that. But when you have issues like maybe an accident, something you did not plan for, something happened, and then the victim is saying, oh, I can let go of this thing, okay, you pay the expenses, the hospital bills, and some of those things. These are matters that can. It resulted in injury, of course, it resulted in one thing or the other, but the parties can actually resolve it. But when it comes to something that is considered a capital offense, there will be no options for you to settle the matter. So I was exposed to that as far back as that 2013 when when I went for the training, and I think that has actually shaped my life, shaped my concept, shaped my understanding about justice and how to get your matters resolved. How to get justice, so to say.
So when I look at it, so yes, you got inspired. Now, how are people taking mediation in Nigeria? Is it being all, or how is ADR being responded to in Nigeria? Is it being lauded? Is it being followed, or people are still skeptical about?
Well, you see, basically as a lawyer, you know, uh, uh, during the time I was trained, I believe that uh, mediation and ADR generally was just, you have people who are trying to promote it, but people are not receptive of it. They've not accepted it per se, especially for the fact that ADR is considered to be non-binding. Like something, everything is free. There is no compulsion. If the other party decides to say, I'm not interested, and that is all, and all things like that. So after my training, I had the opportunity to come back to Kaduna, where I am based here, to do my national service. And after which, I was so excited when they, around 2014, thereabout, Kaduna State of Nigeria established a multi-door courthouse. So with the establishment of Kaduna multi-door courthouse, I was very, very happy. Like, I have been trained, and then now I have an opportunity to an avenue through which I can put my skills into practice. So I quickly applied and followed up, with the center. But unfortunately, the center was just there dormant, and then, it was not functioning as it ought to. And then that actually affected me. But what I did was I actually brought in some of the things I've learned in ADR through my practice. So when I had opportunity to handle matters, you see that those skills are coming into play. Although one of the things that actually discourage people from, especially lawyers, from embracing ADR in Nigeria is the fact that, when you begin to talk to someone, like you have a lawyer on the other side, and then you are the plaintiff, and then you feel that, counsel, don't you think that this is something we can discuss and find a solution to it out of court? And then the lawyer will begin to feel that your matter is possibly weak, you cannot defend the matter, you cannot establish your case, and all things like that. So with those kind of attitudes, anytime you want to approach someone for settlement, it will be as a sign of weakness. So, but that notwithstanding, I kept doing, because majority of my matters are actually settled out of court. And so even when I was the one going to court on behalf of my client, I had an instance where I was employed to eject some persons out of a property, and then I got, I served them the necessary notices, but at a point, I started making arrangements to see how we can discuss, and then we discuss and we find an amicable settlement. And then the owner of the property was like, this is not what I asked you to do. I said, just eject. I didn't say you should discuss with them. I didn't say you should settle anything with them. Just get them out of my property. And then, for me, it's a sign of fulfillment because it gives the parties opportunity to discuss and make arrangements as to how they are going to go about it. Yes, I'm leaving. I'm supposed to pay you your money. I will pay you so time. And these are terms that we draw out, written, signed by the parties, and we file it in court. And that settles the matter. So in Nigeria, as of now, I know that there is a lot of development when it comes to ADR, but still people are skeptical. I remember one person asking me in mediation, if you ask the other party to come for a mediation session and the person refused to come, what will you do? Can you force him the way the courts do? And then I said, oh, you cannot force him. But I believe that when two parties have a dispute, and they have an interest in the matter, I believe that deep inside of them, there is this desire to get this matter resolved. It's just that sometimes the way and manner we go about it. Now, come to think of the way lawyers write their letters. They write a letter and give you a threat that if you don't pay up within 7 days or so time, I'm going to take an action against you. The moment you serve someone, a normal, reasonable human being with such kind of letters, the first thing he does is to bring up his defense, and then the pride in him comes out. What does this person think he is? Is it that I cannot get the service of a lawyer? I'm going to defend this matter. I'm going to prosecute it. I'm going to do this, even if it means borrowing. I will do it. So even the way and manner lawyers write letters, demand letters, and all of those things, it will stir up a lot of issues for the other person. So because of those kind of things, as an ADR practitioner, when I'm writing a demand letter, I avoid some of these things. I write it in such a way that the person on the other side will see that, oh, so these people are willing to discuss the way out of this, and all those kind of things. I will not actually threaten the person, in my letter. So all these things are things I've learned from what the training I've got. But so gradually the problem we have also is with the lawyers, because the lawyer will tell their clients, just forget about them. Even if you go for the session, don't respond, just attend for formality's sake, and then we'll tell the court that we have not resolved. And in our laws, we have what is called pre-trial conferences. Okay. And this pre-trial conference is supposed to be a time where the disputing parties will come together and discuss and identify issues that they can resolve and issues that they cannot resolve, so that only the matters that cannot be resolved will be taken to the court. So, but you see, it has become a practice for us as lawyers here in Nigeria. We just file the forms. We don't even meet. We don't even do anything. You just say, is there any matter that you resolve? None. You just fill the form. You file it in court. The other person also fill his own and file, without meeting, without looking at the issues, without looking at things that can be resolved. And you see, you have commercial transactions. You have issues that involve businesses. And as you do some of these things, you file the matter in court. It takes, sometimes they will give you 2 weeks or 3 weeks or 1 month adjournment. And then you just come to mention a matter. After you mention it, they say, okay, we want to take another date for hearing. Before the hearing, somebody file another application, and that is how you keep dragging it. So we have made effort. In fact, like in Settlement House ADR Training Institute, sometimes we take the effort, we conduct trainings, and we give free slots to MBA, Nigerian Bar Association, the branches, and sometimes it's so unfortunate that you see some of them not even responding. They are not even attending the training, not even talk of giving a discounted rate. For someone who did not see the reason, the need to accept a free slot, it will be difficult for him to accept a discounted slot. So that's the battle. But I'm happy that with the development, NBA, the national, has now inculcated ADR in some of its activities, and it has organized some seminars about ADR, getting experts in the field to talk to lawyers, organize seminars, organize sensitization, and collaborate with some of the ADR organizations to bring to get lawyers aware. And the unfortunate thing is that our rules of professional conduct as legal practitioners under section 15 of 3D of our rules of professional conduct 2007 clearly says that it is a professional misconduct for you to proceed to trial without exploring ADR. It's in our laws. So, but because there is no awareness and this fear of, also, I think clients also contributes to it. When you help a client resolve a matter so quickly and so easily, the client will be like, you're asking me to pay you for what? That kind of thing. So lawyers are reluctant in exploring ADR for their clients. They prefer a situation where I will file a matter in court. I say, bring money for us to do service, bring money for us to, we need to file a counter, you need to do all of those things. They feel that you are doing something very serious and you are doing something to earn your fee. But where you explore ADR and the thing comes that easy, you just sat down, you discuss, you agree, you settle, then the client will feel reluctant to pay you your fee. So I think that's one of the reasons why lawyers in Nigeria are reluctant to accept ADR, because it seems to be a way of either making them not to get their fee, or that, especially for the fact that you have non-lawyers. They said the profession is open to non-lawyers. It's not the exclusive preserve of lawyers. That kind of thing. So you are bringing a non-lawyer to share in our profession, to do something and earn a fee, and then you are telling us we should accept and promote it. It sounds somehow. But overall, I feel that there is a serious improvement in the way and manner both clients and parties are getting to embrace ADR. And I believe that when we have more lawyers who are trained and are sensitized on how to go about exploring ADR with their client or explaining to them, like you can say, okay, my fee is $5,000 for $50, for example, and then this is what we need to do in court. We'll file this and that. When you settle your fee, you cannot introduce your client. You say, but we have other options of trying to see how we can resolve this matter, possibly within the shortest time possible, considering your interest, your investment, your money, and all of those things. Would you like to, explore something like that? You say, oh, why not? Then you say, okay, there is something called ADR. And then when we explore it, we'll have the opportunity to discuss and see. I believe that we'll be able to get this thing behind us within the shortest period of time. You see, with that, you have charged your client, you have received your money, your fee, and then you have helped your client to get the matter settled as quick as possible. So the issue of, oh, you will not pay me my fee and all of those things will not come up. So I believe that we are growing, and now we are having organizations, ADR, private organizations, court-connected ADR centers, all over, that are promoting ADR in their own little way, and we are hoping that more is going to come up. Now, one final thing about development in ADR in Nigeria is the fact that, for all this while, we have been practicing ADR even in an informal way, from our traditional settings, under our religious backgrounds and all of those things. We have been practicing it, but it is not formal. But, with the introduction with the first ADR connected, court-connected ADR center, that's the Lagos Court multi-doc courthouse in 2007, that is where Nigeria began to adopt this formal way of resolving conflict or disputes. And then from there, we have institutions and other ADR centers, that have been pioneered by this first ADR center, court-connected ADR centers. And they have done they have contributed a lot. Now we now have, for the first time, we have a law that regulates ADR. We used to have the Arbitration and Conciliation Act in Nigeria, and mediation is not even mentioned. But now in 2013, the last president, the former president of Nigeria, has signed into law, which is a national law, the Arbitration and Mediation Act. Now, for the first time, we now have a law that talks specifically about mediation and that has national application. So you see, with that development, lawyers will now know that they have a law they can rely on. It has prescribed how settlement agreements can now be enforced, either as contract or as consent judgment, or as, it has prescribed the way and manner these things are being done. So with this development, I believe that more people will now see that they have a legal basis and they have the legal framework to rely upon to be able to promote ADR activities even within their firms.
That's really a nice perspective. And I think India or Nigeria both are following the same course. India also had arbitration and conciliation going on, and then with the Mediation Act going. So, quickly, because we have not much time now, uh, what are your final good advice to young people in the field? Anything that you would want to say?
Well, I believe that for the young people in the field, what they should do is, I feel that they should all embrace ADR, embrace it to the point of, like, for example, what we do under Settlement House ADR Training Institute. We collaborate with ADR organization at the university level. And sometimes we organize seminars, sensitization, and even certification programs for them. We believe that, by the time you have these young ones at this early stage of their career, before they even become lawyers, get to know that there is an option of resolving conflict and disputes that they can make part and parcel of their practice. You are developing a very comprehensive professional that knows the way and manner to go about getting his clients' interests, protecting his clients' interests. Especially, when you look at the 21st century, the clients are not interested in all these legal jargons and all this stress in court that you stay for over 20, 10 years, you are struggling. No, they want results. Especially, you just look at the way dollar is increasing. In Nigeria now, you see that a dollar is about 1,100 or 200 or 300 to a naira. $1. So you will see that, clients are not interested in investing, and then the result of their investment is nothing to write home about, because you have engaged in a litigation that will take the next 5 years, and you will not know you will not know the value of the money you are going to get on your investment at that time. So I feel that the young people who have embraced ADR, they have done a good thing. But those who are not aware or they have not yet embraced ADR, I think they should do. This is because, whether you are a lawyer in training or whether you are a non-lawyer, for example, if you are a medical doctor and you get to know about ADR and you decide to say, I want to embrace ADR and make it part of my practice, do you know what you have done to yourself? At the graduation, you become a medical doctor, and your colleagues have got to know you as someone who helps people resolve conflicts. And then when they have conflict that has to do with medical law, negligence, they have issues, hospital, nurses, doctors, pharmacists have disputes, they will have a reference point, because we are trying to promote a situation where we have people with subject matter expertise. So you now have a doctor who is into resolving medical related disputes, and you now have an engineer who is into resolving construction related disputes. So when I have a matter and I'm an expert in the field, I will not need to employ the services of an expert. Like I enforced an arbitration award back then, that the arbitrator was a quantity surveyor and was an arbitrator. So she doesn't need to employ the service of surveyor to help her quantify the amount that should be paid to the person who awarded the contract, because she has subject matter expertise. So I believe that when young people embrace ADR, and they merge it with their specialization, they become more relevant to their society. This is because, conflict is inevitable in every field. So you can avoid the issue, the situation of unemployment. When you have developed competence in ADR, you can actually be practicing ADR without any formal maybe office or organization. People can reach out to you. So with that, you reduce the rate at which unemployment is affecting our societies, especially the young professionals, and then you add more value to the society. And specifically for those who are either practicing one religion or the other. For me, for example, I'm a Christian, and then the Bible has clearly stated and has given me different bases. He says I should follow peace with all men, and he has given me a ministry of reconciliation. So you see, if I'm doing AGR, for example, I feel that I'm also performing my responsibility as a Christian, because it gives me the basis. Then you have Christian and Christian having disputes. Why can't they use the Bible as the basis of their resolution? So I feel that, yes, this is something that is open. It has given us varieties of ways. You can practice it as your faith, you can practice it as your profession, you can practice it as, different other areas. And now when we have a lot of media practitioners,
with that, we have to say thank you to you. It was wonderful talking to you and with your nice perspectives. And we wish all the best to the settlement institute of yours to make a mark in your area and develop the practice of ADR and make it work for the young people, for everyone. Thank you so much. It was a pleasure having you on board.
thank you very much, Sonal. It's a pleasure discussing with you. And I look forward to other opportunities where we can discuss important issues and matters that will contribute to the development of peace in our societies, in our nations, and the world at large. Thank you.
Thank you so much.